Good morning, students. It's our next chapter, chapter number 3, Judiciary. To protect the liberty of individuals, there is an extreme need of an independent judiciary. Generally, it is the founding stone or the base brick of the modern democracy. The writer Montesquieu had commented on this that the success of democracy it was necessary to maintain all the judicial functions from the legislative and the executive functions, to maintain the independentness of the judiciary. The existence of judiciary is an essential term, or we can say that atom or element of modern democracies. Now, why the judiciary is important for us? Because judiciary plays various role in our day-to-day life. For example, judiciary settle down the disputes to establish the rule of law, helpful in maintaining the socio-economic changes. So, settlement of disputes. Judiciary, several sorts of dispute relating to property, diet, fight, murder, theft, robbery, etc., often arise between the citizens. These crimes may be very dangerous and in nature. They may relate to the civil and criminal matters. Several courts have been established to settle these type of disputes and maintain peaceful atmosphere in our society. After that, the various disputes between the governments, means one state's government to the other state government, one state boundary to the other state's boundary, the center government and the state governments, the citizens and the center government, related to the fundamental issues. So judiciary settle down all these disputes. Now the judicial precedents, very often there are many cases before the judiciary for which there is no law. These are only based on the basis of principle of equality. Similarly, these type of disputes generally arise in our society. So decision of the judges or the court in such cases are authorized, such as judicial precedents. Now the interpretation of constitution in a federal state or in a federal nation, the Supreme Court acts as the guardian of the constitution. It is the legislature or the executive makes a law which is against the constitutional provisions or related to the fundamental liberties of people, then the judiciary can declare it as void or useless, or judiciary can interfere in that condition. Play a role of advisory. The executive can seek the opinion of judiciary in the matter of public importance or the questions related to maintain the law. The Supreme Court's opinion in this regard is quite valuable or very important, as the questions involve on the matter of public importance or for the social welfare. PILs, the public interest litigations. In poor countries, mostly in poor countries or developing countries, a nation whose backbone is already broken, like India, if people cannot afford an expensive system or litigation of judiciary, so in this situation, in these type of cases involving the public interest, a person can raise his voice by writing a simple letter or complaint against the injustice. The letter, known as public interest litigation or PIL, emerged in 1980s in a decision of Supreme Court. Under this regard, Supreme Court Judge Justice Krishna Iyer opened it as a great success of judicial process which wiped away the tears of poor, are very helpful for the poor people who cannot afford the costly procedure of the judiciary. Now the protection of the basic rights. Judiciary gives protection to people's right. If any official machinery or public servant or any other state machinery or office put an impedient in the promotion or protection of people's right, then the constitution prevent them for doing so. The judiciary does so by using writs like habeas corpus, mandamus prohibition, etc., to restore the rights of the people, to restore or to protect the basic rights and demands of the people. Judiciary also plays an important role in making or bringing about the socio-economic changes. It protects the interest of children, women beyond the labor weaker section of the society, or it even works hard to improve the quality of environment, to provide equal and basic rights, equality especially. So the lower section of the society or the poor section of society remove their inferiority from the social atmosphere. To establish the rule of law, judiciary is important to establish rule of law. Rule of law means the supremacy or the dominance of law instead of any person, as distinguished from the basic attributes, the alternative mode which is not law of determining rights of the individuals. This rule of law continuously interfere by the court so that there is no ambiguity in the law that is and apply to all the citizens alike. Means no one is a dominating or dictator type of figure here. Only the judicial provisions are main and play the major role. No single person having special powers here. Only the judicial provisions are major and important. So the essence of the rule of law is the both the rulers and ruled should be subject to the same law, and the government does not act in an arbitrary manner. Judiciary acts as the guardian or of the laws of rule of law. Now the rule of law include that no person can be punished except to break of law. In it means that the equality maintain equality before the law and equal protection of law. No person including the PM is above the law of the land, and violation of laws involves punishment for for all the irrespectives of the status of the other. Rule of law guarantees people the rights, basic rights, fundamental rights. In modern sense or in modern democracy, we generally say that the freedom of individual must be protected only under the authority of law. Justice must be regarded as an end in itself. So we can say that rule of law is the fundamental principle of all the modern judicial system, as it ensure the equality of all the man, woman or the human being before the law. Absence of special courts for acts of official and punishment only to those who are guilty of the violation of law. Now we have a need of special or independent judiciary. Why we need that we have a special or independent judiciary? Indian constitution provides for a constitutional democracy in which the power is divided on the geographical or the functional basis, because we are very large. In term of geographical basis, the power is divided between the center and the state government according to the state list, the union list and the concurrent list. While on a functional basis it is divided between the legislature, executive and judiciary. The judiciary in India has been kept separate from the legislature and executive on practical grounds. Means judiciary have a right to interfere in executive and legislature, but both the organs not having a single right to interfere in judicial process. So to maintain this, it is extreme need for an independent judiciary in India. as on the following grounds: that interpretation of constitution, the supreme document in India is the constitution, and various organs of the government derive their power from it. It is imperative that differences are means bound to emerge between the various organs of the government. It is depend an impartial machinery. It remove differences. The function is performed by none other than the judiciary to maintain or to interfere in any organ. To it gives a strength to the federal nature of Indian polity. Means in our system, powers are divided into the different levels and organs of the government, and the government was established in India where powers are divided between the central and states. Naturally, the disputes are bound to arise between the center and the state government on various issues and matters related to the division of powers in the constitution. In such a situation, judiciary play an important role. Here judiciary therefore play a safeguard that the federal nature of Indian polity is continuously maintained. The part 3 of the Indian constitution provides for the fundamental rights to the Indian citizen, and independentness or judiciary play a role of guardian of the fundamental rights. It is necessary to provide for a defense of these rights, so that if a citizen feels that his rights have been taken away, he or she can go to a suitable authority to get back the rights. The task is performed by the judiciary, which acts as a guardian of the fundamental rights, uh, them by any public institution or officials. Now the provision ensuring the independence of judiciary, that the President of India appoints the judges of Supreme Court and High Court on the advice of Chief Justice of India and Chief Justice of the concerned High Court in the state. The appointment is done by prescribing certain minimum high qualification in the constitution and are free from the personal views, means the favorite type of views or any personal other basis. A judge can be dismissed from service once appoint cannot be dismissed from his service, sorry, only dismissed on the basis of the process of impeachment type. Once appointed by they retired at the age of 65 years or at the expire of their term of 6 years, whichever come first. The judges can only be impeached like the president on the ground of provide the misconduct or misbehavior by the parliament. The salary and allowances of the judges of the Supreme Court are charged from the consolidated fund of India and cannot be reduced by the parliament during their tenure. The action and decisions of the judges in their official capacity are immune from criticism. Even the parliament cannot discuss the conduct or the work of judge except when a resolution of his removal is being considered. A retired judge of Supreme Court cannot appeal in any court or tribunal of India. By keeping the judiciary impartial, independent and autonomous, the fundamental rights of Indian citizens have been preserved. Now the Indian judiciary at the highest level, the Supreme Court, and then the state level, the High Court, and in all the local level, the District Court. The Supreme Court jurisdiction is the decisions binding on all the courts, can transfer judges of High Court, can move cases from lower court to itself, can shift cases from one court to another court. And on the state level, jurisdiction is listen to appeal from the lower courts, can issue writs for restoring the fundamental rights, can deal with cases within three jurisdiction of the states, has control of superintendence over lower courts. On the district level, deal uh, deal with the cases arising and within the district, considers appeals on decisions given by the lower court, decide cases involving session, criminal offences. And the second part of the district court is subordinate courts, the jurisdiction and consider cases or cases of writ and criminal offences. Now the organization means the Supreme Court. The Supreme Court at present consists of one Chief Justice and 25 other judges. In 1950, when the Constitution was enacted, there were only 8 judges. On 28th of January 1950, it was 8 judges. In 1956, the number was increased to 11. In 1960, the number was 14. 1977, the number was 18, and in 1980 it was increased to 25. So at present 25 other judges and one Chief Justice of India. Appointment under the article number 124A, the Constitution provides that a judge of Supreme Court will be appointed by the President to consult with such judges of the Supreme Court and of High Court in the states as the President may deem necessary. In the case of appointment of judges and the other Chief Justice, the Chief Justice of India may be consulted. There is a few controversies regarding to the appointment of Chief Justice of India. Means on April 25, 1973, when the claim of 3 senior most judges, it was done during it was happened during the Indira Gandhi's government, or we can say that Indira Gandhi's domination. Simply, he refused to appoint the senior 3 judges and appoint the 4th junior judge, Mr. A.N. Roy, was the Chief Justice of India. So it was very big controversy at that time. Now the qualification for becoming a Supreme Court judge should be a citizen of India or a judge in High Court for last 5 years, means he or she having the experience of judge in High Court, or 10 years experience, and should be in the eye of President as a most distinguished jurist, means his work, his experience is quite good. Now the salary and allowances, nearly monthly got nearly 2.8 lakh, while the other judges get a salary of 2.5 lakh. It's quite good. Eligible for free accommodation and all the other allowances. After retirement, they can get pension as prescribed by the parliament, or further they cannot practice after retirement in any court. To maintain the integrity and the independence of the judiciary, the salary and allowances of the Supreme Courts are charged from the Consolidated Fund of India. And though the Parliament can debate, it cannot vote upon the expenses inquired by the Consolidated Fund of India. Each judge is administrated oath by the office of the President to honor the Constitution with loyalty and discharge duties. The tenure, Article number 124 describes that the Supreme Court judges would hold office till the age of 65 years. If he or she wants to retire earlier, he or she should send his resignation letter addressed to the President of India.